Good afternoon. Welcome on in to From Day One. Today we start with a subject more, trying to suppress in court.
Numbers 21 through 24, People versus Daniel Grady L. and Shatina Grady L. 21513 FH and 21514 FH.
Are we going to do both of these together? I mean, they're the same motions from the people. They have slightly different fact patterns, and they have two different lawyers. So whatever you guys want to do, what do you want to do?
There's no objection from Mrs. Grady L, Your Honor, to do both together. It makes sense, I think.
Yes, probably a star on behalf of Mr. Daniel Grady L. Yeah, no objection to doing this all together.
All right, and Mr. and Mrs. Grady L, can you hear us?
That's fine. Yes.
All right, so let's start with, let me get the attorney appearances first. So, Ms. Calapu, is this your appearance today? All right.
Yes, Your Honor. Good afternoon. Melissa Callis on behalf of the people.
All right, and we have Mr. Starr's appearance. Mr. Amadeo, your appearance?
Good afternoon, Your Honor. William Amadeo, P76194, on behalf of Shatina Grady L. We both appear via Zoom and waive the right to be present in person. And, Judge, I do think Prosecutor Winslow on as well on this matter.
Thanks.
Oh, yes. Tucker is. I'm sorry, yes.
That's okay, Your Honor. Good afternoon, Your Honor. This is the Attorney General Yasmin Tucker appearing on behalf of the people.
All right. Ms. Grady L, tell us your name for the record.
My appellation is Shatina Grady L.
Okay. And Mr. Grady L, you want to tell us your name for the record?
My appellation is Daniel Grady L.
Okay. Okay, I'll fight. That's fine with me. Appellation is a little unusual, but I'll go with it.
Fight.
So,
I like that.
all right,
I'll
today
fight.
is the date and time set for the people's motions to admit, acts of prior motion 404B motions. So that's in the biz. Notice and a motion in limine to admit prior acts. I've had a chance to review the motions and the responses and the briefs. I'm happy to hear from either Ms. Palafu or Ms. Tucker. Highlights, again, you don't need to repeat, but I'm happy to hear your oral argument, and then I'll hear a response from Mr. Amadeo and from Mr. Starr. Okay?
Thank you, Your Honor. Your Honor, I'm not going to go back and repeat everything that I had previously written. You did have all the facts regarding the prior conduct, and you have my motion with all of the law. I would just like to make a little response in regards to the defendant's motions themselves. In regards to Mr. Daniel Grady L's motion response, I just wanted to also state that during that response, there was no statement of defendant's theory of the case in order to back his argument that these acts would not be relevant. In order to say that, you would need to state his theory of case to show that they are not relevant, and in fact, that there was no statement or theory of the case that was provided. I would just like to reiterate that the people do intend to admit this evidence to show that there was an absence of mistake or confusion as to what was occurring at the scene, or confusion of the officer's commands, that there was to demonstrate the intention to obstruct, which goes with the absence of the mistake or the confusion, and to rebut any argument of the defense to the contrary of those statements. In regards to my response to Ms. Shatina Grady L's response.
Let me interrupt.
Yes.
So, while we're on Mr. Grady L's motion, I just want to be clear that the prior incident that you are seeking to have admitted is that 2019 incident, correct?
Yes,
There's a slight difference between the two defendants. One is the 2019. Mr. Grady L is singularly that 2019 incident, while Ms. Grady L includes both the 2019 incident plus another one, correct?
Yes.
Okay.
Yes, it would just be that one incident for Mr. Grady.
So let's do this one at a time. So let's go ahead and I'll hear from Mr. Starr. If you wish to respond to what the prosecutor has just stated on the record or anything else, you may do so. But I have reviewed everything. So go ahead.
Yeah. So first is to my alleged allege facts, it's clear, and I do provide some basis here as to my client and why, if the 404B were allowed to come in, it would basically strip away what I'm alleging in my facts as to what occurred. But to put it simply and briefly, normally with the full.
So you don't want it to come in because it'll prove that you are going to lie to the judge. Interesting. I believe it's content from the Dutchball movie that put it best. Interesting strategy. Hope it works out for you.
404B motion, you're talking about a prior crime, a prior act, right? Here in this situation, reading plaintiff's motion, they're not only speaking about a prior act, but also too, defendants allege affiliation with an organization, and basically saying this affiliation with this organization is the reason why he is conforming to these responses with the police. 404B is plainly states that's not allowed. Evidence of other crimes, wrongs, or acts is not admissible to prove character of a person in order to show action in conformity therewith. They're speaking about things that are character evidence. They're saying, hey, he's acting in regards to how this more organization acts. But then on top of
Can I
that,
interrupt you? Mr. Starr?
Please.
Let me interrupt you. I don't know why your client or Mr. Amadeo's client turned their video off, but this is the best we got with Zoom, so you can't elect to turn your video off during a hearing. Go ahead, sir.
I didn't turn my video off, Judge.
No, your client.
Oh, I apologize. I didn't know that.
Okay, go ahead, Mr. Starr.
Where was I? Oh yes, but then on top of that, they don't provide any type of substance, any type of materials, any type of literature or anything of that nature to show that yes, this organization does act in this regard when it comes to law enforcement. This is an assumption. As I stated, as I cited in one of the cases, this is character evidence masquerading as one of the exceptions. This is purely character evidence, and if it were to be omitted, this would violate my client's due process right to a fair trial because it shifts the focus from the events of that night to what are their beliefs, right? That's what we're talking about. What are their beliefs? Which again, plaintiffs are assuming their beliefs.
All right, Ms. Peliku or Ms. Tucker, anything to respond to that?
Your Honor, I would just indicate that my motion has absolutely nothing to do with their political beliefs, or I'm not really sure how to classify the organization, but that honestly I believe they probably will bring that up themselves in trial. But that is not the focus of the argument. The argument is solely based upon that conduct that the police report was attached.
Okay. All right. And then since we have kind of argued that issue, I'm going to shift it now to Ms. Grady L. And again, there were two incidences in that question. So is there anything else you wish to comment?
Your Honor, I'll just state the same thing, that the response to my motion does not provide any theory of the case or any explanation as to why this information would not be relevant. The people intend to utilize this information for the same purpose as previously stated, to show that there was an absence of mistake or confusion, and to show that there was the intention to obstruct the officers when going to that scene, and to rebut any argument from the defense to the contrary.
Okay. And Mr. Amadeo, any specific response for today's hearing?
Your Honor, you read our reply, and so did your staff, and I'll rest on that. I'll just add a couple things briefly.
Then you're not resting
I don't know
on
what
it.
the Attorney General means when there's no theory. This squarely rests on the Denson case. There's no striking similarity. In fact, the only similarity, Your Honor, is that my client's been a victim from 2 police agencies. I'll leave it at that. Thank you.
All right. So it's actually kind of hard for me to articulate exactly where I'm going with this. You're gonna have to bear with me. In gross summary, I've reviewed all of the case law and the relevant rules of evidence and core rules on this issue. And so what people are seeking to admit is evidence under MRE 404B that would allow a jury to hear prior criminal action or activity to essentially to show intent, absence of mistake or accident, or a system doing an act. It's somewhat limited to those purposes, and so I am cognizant both of Mr. Starr and Mr. Amadeo's arguments, but looking at and that's why I was kind of trying to articulate the particulars of the differences between the two. So the two defendants share one incident that the people are seeking to admit prior evidence on that March 9, 2019 incident, I believe, in the parking lot. And Mr. Amadeo, you bring up the question of striking similarity, and actually I do find that there is striking similarity in what happened in that 2019 incident as well as what is alleged in this case. I will note for the record that in the 2019 incident, there was a refusal on the part of the defendants to identify themselves, provide documentation. There was a refusal to cooperate with the police agency.
Hold on a second. Sorry, guys. Hit the wrong button. Really? Lost it that bad? Hold on. Here we go.
Numbers 21 through.
And that's why I was kind of trying to articulate the particulars of the differences between the two. So the two defendants share one incident that the people are seeking to admit prior evidence on that March 9, 2019 incident, I believe, in the parking lot. And Mr. Amadeo, you bring up the question of striking similarity, and actually I do find that there is striking similarity in what happened in that 2019 incident as well as what is alleged in this case. I will note for the record that in the 2019 incident, there was a refusal on the part of the defendants to identify themselves, provide documentation. There was a refusal to cooperate with the police agency. Eerily similar, a family arriving, surrounding, and videotaping the situation, and that allegedly in this case, in the current case, but what I believe was confirmed in the earlier case was the police had to act to not only break windows but physically remove the defendants. So I do find that that the evidence for March 2019, that incident in the Walmart parking lot, is admissible under 404B. It is not the finding in my analysis of this that it is unduly prejudicial. I believe there are methods the defense can cure any potential undue prejudice with both jury instructions regarding the 404B evidence, as well as, yet to be determined, examination and cross-examination of witnesses. So I believe the defense has the mechanism to either cure or mitigate the potential for undue prejudice in this. I will grant the people's motion to both defendants on the 2019, I'm just going to call it the Walmart parking lot incident. The other interesting piece, though, is looking at Ms. Grady L's other instance. So the people are seeking to admit evidence from a December 2019 high-speed chase. And while there are some similarities between the end result of that chase, I do find that under the Benson case that there is not a striking similarity. and that I am going to deny the people's motion as to that incident. So the ruling of the court. So I will sign that order upon submission. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. Well, hold on one second. Thank you, Your Honor.
Hold on. Is this also a pre-trial or just these motion hearings?
I thought it was also a pre-trial.
I know. Hold on a second. Before I let you go,
Yeah.
settle down. Let's get to my dockets. All right, so we do have pre-trials in both of these matters. I will tell both counsel that so you understand this, that I don't have fingerprints in either case, and we can't continue. I don't know if there's going to be a trial in this matter. I don't know if there's going to be a plea in this matter, but I'm going to order that the fingerprints be taken care of before the next event, whether it's another pretrial, a final pretrial, or whatever that is. Otherwise, I'm going to need to remand your clients to get those prints done. So I'm just reporting that to you. I'm not going to remand them. That's not my intention. But just so that you know that we have to have the fingerprints done. Okay?
Your Honor, I'll get on top of that, but I believe when I called the sheriff's department, they were done the night of the arrest. I think they've been done another time. If they're not in your file,
Mr. Amade, this is a bit of a head scratcher. It's true. But the fact is everybody gets fingerprinted when they're arrested, but somehow the fingerprints don't get attached to the court file. And we can't proceed without the fingerprints being appropriately attached. So there's a fingerprint order. They can either go get re-fingerprinted, or you can figure out a way to get the prints from the sheriff's department into the court file, and we can do it. So you believe me, you're not the only one to say that. But I'm just letting you know we don't have them. So that's kind of where we are. And so I'm not going to set another event for next week. I'm not saying I'm going to remand your clients in a week. But what I'm just saying is we got to get that done. So what do you think, counsel, that the next step in this trial is? These are 21 cases. So we're at pretrial status. But my next step would be to set a final pretrial and a trial date. So is that where we are? Or is there further activity that needs to happen?
We have some motions to file, Your Honor, but we could certainly do that before whatever your trial date is and get a date from your court. If we want to set a trial date for maybe March, I don't know what your docket is, Judge.
I mean, I don't know if March is kind of a random and arbitrary month, but it would certainly be in 2023. So January is a civil month, so it's as likely as not we might set we could set a trial date for late February, early March. That's fine. We'll do a final pretrial end of January, early February. Any motions obviously would need to be filed and heard on or before that final pretrial. Okay?
And then, Your Honor, I just wanted to put the offers on the record, if I could.
Sure. Go ahead.
So I just got these offers, so I just emailed them to both defense counsels just like a moment before the hearing started. So they have not had time to process them or anything.
Okay.
But I just wanted to make sure that they were on the record. As for Mrs. Shatina Grady L., the offer for her is to plead to count 1, which is the R&O causing injury, and we would dismiss the remaining counts. I believe her guidelines would be 12 to 24. We would leave the sentencing in the court's discretion. As to Mr. Grady L., the offer would be to plead to a reduced count 1 to an attempted R&O, which would be a 1-year misdemeanor, and we would dismiss the remaining charge, and we would again leave sentencing in the court's discretion.
Okay. Counsel, you heard that, and you'll have a chance to discuss that with your clients, correct?
Correct, Your Honor.
Yeah, I received the prosecutor's email on that.
All right. So let's go ahead and set a final pretrial date toward the end of January.
Let's do January 30th for final pretrial.
Okay, and then trial date would be end of February, early March, kind of thing.
We could do February 27th or March 6th.
March 6th will work better.
All right.
Could we go
March
1 week further? I'm in trial on March 6th and February 27th, Your Honor. I apologize.
Okay.
March 13th.
All right, so next one, March 13th. How does that work?
That works for me, Judge, if that's acceptable.
That
All
works
right.
for
people.
All right, good. So we'll set the trial date then for March 13th. That's 8:30 a.m. Monday for jury selection, and we will see you at the final pretrial, or if there are other motions to be filed. You don't have to wait till that final pretrial date, but that's the next court event. Okay? So I need to have the prints done by final pretrial, and I did just check while we were on the hearing. They weren't printed. The sheriff's department does not have fingerprints for them, so that's going to need to happen.
Okay.
All right.
I was told differently. I apologize. I'll get on top of that.
No, I'm not. I wasn't there, but I'm just letting you know what we did. So okay. Thank you.
All right, thank you, Your Honor.
Yep.
Thank you, Your Honor. Alrighty. Let me get us another one as we continue. I don't want to go that long. Yeah, let's do that one.
Edwards versus Guerrera, file number 1950, set for motion to set aside default.
Good afternoon, Your Honor. My name is Autumn Edwards, plaintiff, and this is.
And my name is Nettie Carter Williams.
So this is motion to set aside the default judgment. Go ahead, counsel.
Your Honor, good afternoon. This all stems from my two clients.
Yeah.
They try to help out the plaintiff, and I'm not sure where their relationship soured, but she came with threats after threat. I'm going to go to court. I'm going to do this, and the clients just it just became empty threats. When they were handed some sheet of paper, they truly did not know this was in fact a summons. They just thought it was something that she was trying to do to scare them or trying to intimidate them. And they really had no intention of ever, if there was ever a hearing for them to miss this, to miss their hearing date. Because as it was in the past, the plaintiff has made some remarks to them. She sent them documents in the past that said we're going to sue you, that were not actually filed with the court, and by pure mistake, they truly thought this was the same thing. The paper was not legible as well, so that's why they also thought it was something that was not filed with the court, and they only found out when my client, a couple days after the hearing, went online to look, which was her first time trying, ever doing so, and she's seen that there was a hearing that she had missed, and there was this judgment against her.
And there was no hearing. It was strictly failing to. That's what I was checking on. It was strictly a default by failing to file an answer.
Oh, okay, gotcha. So we have in fact fixed that error. We have in fact filed a response to the answer. We did so immediately after she reached out to me to let me know that this had occurred. We asked that the clients be given the right to defend themselves, and this was truly an error that they had no intention, no disrespect towards the court at all.
There was a lot of documentation sent here. We received looks like about a half inch of paper July 15th, and these are copies of text messages, so it looked as though they were just printed out some messages going on in July and other dates. I feel like I have to go through this so we just all know what we're dealing with, because it's not real complete. No attorneys have been at it until yourself. So, it says, July 15th, please forgive me for giving you all these printouts. It's just very difficult to defend myself against this woman who brags about being a good liar. I have just a few minutes to simplify my suit. Talks about slander. There's a little blurb on that. A bullet point for discrimination. About the witchcraft and religion. There's about slander, offensive character, discrimination again, trespass, going in without permission, illegal activity, taking prescription medication, too much to write, son is terrified, threatening to lie to my Section 8 people, hope to make me use on the basis of a voucher, offered me money to leave, I said double my deposit and we will. That was this document. I'm not quite sure. I guess it fleshed out a little bit more of what it is, but some of these are not actionable in the district court. They are equitable claims. That being slander, discrimination. The only one that could be is something to do with the lease. It could be illegal activity or trespass. I don't know. But the other ones are, as counsel knows, but not actionable because they would have to be in the circuit court. Those are equitable claims. So that's what was also filed. So then there was the next paper that came in. So the first box says I requested default entry against Mero Guerrera for failure to appear. That one that she signed is not, as you know, accurate because she didn't fail to appear. It was that she failed to file an answer. But obviously she failed to file an answer, so it was granted because it was defaulted by not filing an answer. So then we got this. We got your appearance, and we sent you the hearing regarding your motion to set aside. You had filed that. So we got that. And the next, I'm getting near the end here, but then there was a filing on August 29th. Did you ever see that, counsel? It says, hello, judge, the lawyer is lying to the defendants and it's not cool. Did you see that?
I don't think so, no.
Okay, it's a one-pager. I'll just read it to you so you know what's up. There's no secrets here. The lawyer is lying to the defendants and it's not cool. A woman named Nettie Carter personally served Mero Guerrera in the presence of myself and the tenants in Unit A outside the property. The landlord went completely off. She began to read that she was being sued, yelled at me, stating she would see me in court. Now, this attorney has asked you to set aside the default with a lying excuse that it was mailed to her, no visible for her to read. May I have your permission to give the server the Zoom link to testify she served Mero personally as the attorney here to lie for her. Thank you, Autumn Edwards. And I said, well, this is a hearing, so whatever witness you want to have, you can bring. Yes. In this case, counsel, your argument was that they did not know the document they had. It wasn't real clear. They did not know it was, in effect, a real court document due to prior instances where they have threatened it and not actually followed through. They filed the claim and no answer was filed, and so to set aside the default, the argument would be a reason for not appearing, in this case not filing the answer, and the other one would be that there would be a meritorious defense if they were allowed to defend their claim. So what is that argument?
As you said, the claims were not equitable, the majority of them, if not all of them. So there would be no relief this court could grant. Everything else that she said was downright, especially where I just heard now where I would, other attorneys that would lie to the court, things like that is we hold ourselves high standard here, and our goal here is to look into the truth, and the truth of the matter is that these people have gone out of their way to help out the plaintiff time and time again, and they tried to go out of their way, and they even offered her financial settlement, not because they had to, but because these are the type of people they are. Even though they were costed them thousands of dollars to the property, which was done by, we believe, the plaintiff. She would not be able to get any relief from the court.
They filed these extra documents, did not send them to you, which offered more detail, however, now indicating claims that can't be heard by the district court. Like I said, Ms. Edwards, they have described the fact that there was no hearing date set, so it wasn't as they failed to appear. There was just to file an answer within 21 days, and basically within a day or two of that deadline, you filed your default claim, which we granted because it was past 21 days. And to set aside a default, they have to give a meritorious reason. First of all, why didn't they file within 21 days? And the other one is, what would be a meritorious defense? So they have described why they weren't sure it was a real summons, so they didn't file their answer, and they are in pro per at that point, not with an attorney. So we give people a little bit of deference if they don't understand something. I looked at what was filed, and it was not real clear on my copy, and it was all kind of running together, and it wasn't bullet pointed. I think the attorney mentioned that there's a pattern of how you file these things, so it makes it easier to read because you argue each section of your claim by paragraph or bullet point that, like you laid out later when you filed more stuff, you kind of bullet pointed it and say, well, here's one claim, here's another. It wasn't done that way, so that was a little bit confusing and may have caused them to seek counsel in the first place. And some of these now are not actionable in the district court. So I don't really know the basis of the $6,500 because as these other things were argued and raised, I don't know if it's for, I don't really know what the $6,500 is for, what you filed. And it might be for some partial things that are good, but I don't know if it's connected to the claims that we cannot adjudicate. So I'll hear from you about this because they had their side to raise it. What do you have to say?
And I told her, well, yes, sir. That was it. So it wasn't nothing else for me to do. That was it.
Okay, thank you.
Your Honor, I'm not gonna waste too much time. The bottom line is, she was served. She was very irate while reading it. It was very legible when she got it. She read it all the way to the bottom. She looked me in my face and said, "I'll just see you in court," real nasty. Then her husband, Juan, said, "What's going on?" She showed him the letter, the summons, and he began to read it and threw his arms up and walked right past me. I don't have any reason to lie, and I believe that this default judgment should stand. When I said that the lawyer will come in here and lie to you, it's true. When he originally read his statement, he said that it was mailed to his clients and it wasn't legible when he got here. No one knew her address was mailed. The reason we knew she was coming by is because the girl expected told me. I told her what was going to happen if there was when we were coming. And she told me she'd let me know because she was bringing us food protected by. That's why she was able to be served. I wonder, and then when he sat here and started speaking with you today, the lawyer, he started off totally different from what he answered to you by stating it was mailed when in fact it was handed to her. They had enough time, just like if it was me that didn't show up within 21 days or respond within 21 days, they would have got granted that default judgment. I don't see why it would have to be taken from me based on him, I guess, being a lawyer. It don't matter if it was legible or not, Your Honor. They could have called the court. All the information information is at the top. Mine is my handwriting. The district court is right on top of the paper. So she had more than enough in the time to contact this lawyer, the same person, to set aside my default judgment to ask him, what's happening with this paper in court. That's the part that I want to read. And also, if I can put this on record,
Yes.
the Condor 3.3. It says, thank you. It says the candor to the court provides it is the duty of an attorney to employ for the purposes of maintaining the causes confided to him or her those means only to consistent with truth and never to seek out and mislead the judge or any judicial officer by false statement or fact or law. So him sitting there calling me a deceiver, a fraud, and none of that has nothing to do with the fact that they didn't respond within 21 days. And I'm none of those things that they called me either. But, when I, just to speak on a little bit of what he said about me threatening to file suit, the threat was my son and I were sleeping in feces filled up to the second step in our home. As you see the pictures that I've sent to you, Your Honor, every 3 days, it was feces. I had to give up my foster children that were there because they slept in the basement. And I kept telling her, if you don't do what the plumber asked you to do, then I'm going to call the health department. She said, go ahead. It's my home. And you can see the smart aleck remarks, but we stayed in this situation since April. The health department came out and condemned it on the 3rd. My child and I have been sleeping in our car ever since then. He's now in the hospital so this wait has been very difficult for all of us. I have no reason to lie, about anything, which is why I sent every text message I could to you and brought my phone to court in the event that you would rather look at her and I speak directly versus me making, screenshots. But this lady has done a lot of things to us. I don't know if we're having a hearing now, but I wanted to stick to the fact that they have not responded in 21 days, Your Honor, and I think I should be in the right to keep my default judgment.
All right, anything additional from the defense, because this is their motion?
Yes, Your Honor. I'll just respond to the plaintiff's accusations of me planning to lie again. Apparently, the plaintiff is perfect and she doesn't make mistakes.
That's not a way to go.
Email, which it does. It was a error, which doesn't change anything. She still has not detailed what the damages came from. Did they come from the claims that have to be heard in another court? Did they come from breach of a contract? Did they come from the lease? I don't know. So we take great offense when our integrity is put online, and I think.
All right. This is what this is about, Ms. Edwards. When cases are filed in court, there's a lot of issue, a lot of angst, a lot of emotion that comes with it, and you can see that in the documents. And it's hard to sort out what it's all about when you don't know anything about it, you haven't lived in it. So we look at it from above here at everything is filed and try to get a handle on what's actually the problem. What's the lawsuit about? Do we have the rules met that we can hear this case? Does it require some additional information to see if we can hear the case? And the purpose of the court is to make a ruling to hear the case itself and allow people an avenue to have their dispute resolved. So getting the case to court is the first thing that happens. And sometimes people don't respond, and there's nothing to do except issue a default judgment, send them the default judgment, and a lot of times they don't respond. And then collection efforts are made, and a lot of times they don't respond. And sometimes they do at each one of these stages. The case law, which you don't know about, but you're held to know because you're involving yourself in the court, ignorance of the law is not an excuse. The law is the law, and we have to follow it. The law is clear, and the case law is part of that, that the goal of the courts are to resolve the disputes, and to do those after people have had a fair chance to be heard, and not by summarily resolving them without hearing all of the people and issues. So if we do decide summarily that the case cannot be heard, that's for very valid reasons, and we have to state them on the record. And the court favors actually getting the case to court and letting the parties air their respective claims. So when you're at a stage like this, where it is the initial answer, the only requirement is, was there an excuse why you couldn't file a written answer within 21 days? They have provided
really not liking this.
a statement that it was confusing, hard to understand what it was written, and weren't even sure if it was valid or not. They did find out fairly quickly that it was valid, but it was after the 21 days. Counsel got involved and then started to file this motion and told them it was a real thing and got them to respond. The problem that we have are twofold. One, they of course didn't file within 21 days, but sometimes while that's a cut and dried issue to get the default, setting aside the default is very common in these cases if they have a meritorious defense of some sort, and that they, or at least a potential meritorious defense, something they can point to say that's not accurate, or you can't hear this case in this court, it has to go to a different court, or they also can talk about why they couldn't even issue a response if they don't understand what was filed. And that's what we have here. I looked at it. I wasn't clear what laws or issues were being argued. There was no lease attached. I wasn't sure if this was a landlord-tenant issue. I wasn't sure if this was a damages issue. I wasn't sure if this was a security deposit act claim.
They're going to get off.
None of that was clear. There was no lease attached, so I couldn't be certain that it involved a lease or did involve a lease at some point. You talked about Section 8. Normally they require written leases for that, but not always, or sometimes the leases are for an earlier time frame and then they go month to month. So none of that was made clear. Now, you are, of course, not lawyers. I don't expect you to follow a lawyer format. You still have to follow the law regardless. So, looking at what you filed, it's not the job of the court to decipher what cryptic notes you're making there to tell us what your claim is. Now, to your credit, you filed additional documents with some bullet points. It starts to show, well, these are the things I'm really talking about. And you highlighted some legal areas of claim. The only legal areas of claim that can be actionable in the district court involve matters of contract law. Very little equity. Landlord-tenant has some equity, like possession of the premises and damages. But issues such as discrimination under civil rights law or rulings concerning defamation of character, those are jury questions of equity, and they can only be discerned and reviewed in a circuit court. So those claims cannot be a part of this case. We're limited to, at best, a security deposit act issue, damages for that, and we're arguing trespass, coming in at the wrong times, interfering with the quiet enjoyment of the property. That's what I'm seeing in your list. Those can be actionable, but they're still not very well fleshed out. Those documents, although were never sent to the defendant, the attorney, they were sent to the court. Under our methods of operation and our rules, if a person is filing a document with the court, they have to send it to the opposing side. Even if there's no attorney, you have to send a copy to the defendant. That wasn't done. If it was done, there was nothing ever received, and no proof of service that it was even filed with them. So we can't have ex parte discussions or documents that are filed and only sent to the court so the other side doesn't see them. So the attorney did not have the ability to see what you wrote. They didn't even know they were in existence. So those documents I'm going to have the clerks copy and mail to the defense counsel, so they get a complete package of what we have in the court. Because it's not always clear that if you copied what you sent, you might forget something, or add something that wasn't filed with the court. So we're going to send a copy of what you filed after the initial complaint to Mr. Mubarak. So he will have that. Based on that, he will review those claims and file a more detailed answer or response, because he hasn't really afforded an opportunity to file one like that. So the fact that there was no 21 days that could be filed, I do not believe that a competent lawyer could have filed a response to what you filed accurately within 21 days. And that's evidenced by the fact that you added more stuff after your original complaint. It just isn't clear what you're suing for. You've made a number of allegations that were not clear. So the purpose of a 21-day rule is to answer what's clear and make your answer indefensible. If you don't know what's being claimed, you don't know how to answer it. So I do believe that they weren't sure this was real based on what you had said. Now, even with that's the case, they did respond quickly after they found out it was, and they got an attorney involved. And the attorney tried to file what he could, but was very limited because of the content of the complaint. So I'm granting the motion to set aside the default, which means that there's no judgment. We have to have the case go forward. So now we can have the dispute discussed and figure out what issues are there for trial and what issues might resolve.
I mean, what are we disputing? You already ruled it in a favor now, and you probably gonna do it in the future. So what's the point? What is all this for now?
Excuse me?
Excuse
me, Miss Edwards. What are you talking about? Are you claiming that you don't understand? Just wait a minute. Wait a minute.
1 days for me, you to do my
Stop talking. Stop talking.
Whoa, you done fucked up quickly. Now I know why this one was packaged with. Let's continue.
Okay, I can see that something is going on with her, but she's alleging now that somehow I have made a ruling in favor of them, and she doesn't like it, so she blanks out. So you have to come back with your camera. We're in a hearing. If you do not, there you are. Thank you. I have made a ruling on a preliminary matter in this case.
Yeah, I heard.
I don't even understand. No, first of all, you can't overtalk. I will give you no, stop. I will give you a chance to talk when I can talk. Stop!
I don't have anything else
Stop!
to say.
Stop!
You have nothing to say.
Stop! You cannot overtalk me because we can't record it. It's a process. So you have to stop interrupting and being so absolutely rude and condescending. And if you leave, this case is dismissed. Ms. Carter, let her know if she leaves, it doesn't come back on camera, I'm dismissing the case. If you want your case to go forward, you have to stay with the court. You cannot talk over anybody because we cannot record this on Zoom. That's why you can't talk over. I will give you a chance to speak like I give everybody.
Dismiss the case, like you threatened.
You do not interrupt. All right, she doesn't want to participate in the case.
Yeah, dismiss the case. You was gonna do it anyway.
Yep, now she's making false claims against me. Mr. Mubarak, she's looking like she's voluntarily abandoning her case. You move to dismiss?
Yes, sir. Move to dismiss.
Okay, case dismissed. Please file an order.
Yes, sir.
Oh, prejudice, motherfucker.
Okay, you're in contempt of court. You're going to be brought into the court. Is she out there? Bring her in.
Bring the idiot in.
Your Honor, she's at 14-1.
She's at 14-1? Okay, I'm going to schedule I want this recorded, and I want to schedule a contempt of court hearing.
She done fucked up.
So make sure you file a copy of this record. Once we have a copy of the Zoom recording,
She done fucked up.
schedule a contempt of court hearing in 14-2 in person.
Because she
Failure
fucked
to
up.
appear will also be contempt of court. This is criminal contempt of court. We'll send out a notice once we have that. The order will say that the case is being dismissed since the plaintiff voluntarily abandoned her claim.
Yep.
Proceed. Voluntarily abandoned her claim.
Yes, she did.
And left the proceeding. I did file the order regarding the motion to set aside the default. The motion was granted if there was good cause and a meritorious defense were established. Plaintiff filed additional claims but were not sent to the defendant. Court will mail a copy of these documents to the defense attorney. Then plaintiff
Went stupid.
committed contempt of court and abandoned her claim. This is criminal contempt for disrupting the court operation and swearing and cursing while on the record.
Because she was dumb.
And continuing to talk. We could not record any of these proceedings with people crosstalk. We only have one microphone. We can't record them actively, so we have to stop people immediately when they are talking. All the information that goes out says that. They are not to talk over each other when on Zoom. She has no respect for authority, it appears, and decided it was going to be her way, or that was it, and she
took that was it.
So we will expect the order to dismiss, and then we'll get a copy of the Zoom hearing, and we will send out a summons to appear in court. Failure to appear will end up with a bench warrant and another contempt of court for failing to follow that. Thank you. Thank you, Mr. Mubarak. Have a good day, sir.
You too.
And thank you, Your Honor. With that, we will bring the afternoon session to a close. Please come back tonight for more fun as we continue to march along here from day one. As always, please make sure you do go ahead and like, share, and subscribe to help us get closer to the goal of 50,000 views, 1,000 subscribers. Suboxy sends those presents, and Google puts us on those algorithms. So again, until tonight, thank you for watching from day one. Have a great afternoon.